Welcome to this on demand adult education workshop, Estate and Medical Preparedness Planning. What you need to know and where you can go to get help with your planning. I'm John Terry, and I will be your host for this event. Now, if you tuned in hoping to get some free legal or tax advice, you tuned into the wrong on demand workshop. I am not an attorney, I am not a CPA, I am an educator. What I want to do in the time that we have in this 60 minutes or so that we're going to be together is I want to educate you on the various aspects of retirement and estate planning, sharing with you important information that's going to allow you to make informed decisions about the type of planning that may be appropriate for you. And as you're having conversations with the team that you're going to assemble around you to put an estate plan together, that you're able to speak intelligently to them and to be able to understand the terms that they may be using that prior to this opportunity to hear this workshop, you may not be familiar with. I also want to share with you some ideas that you may want to think about to make sure you're being a good steward of the resources that you have available for you. Now, why do I share this message? I think it really starts with an interesting incident that happened with my parents. When my sister and I were young, we're talking back over 40 years ago, my parents decided that in the event something were to happen to them, they wanted to make sure that there was a plan in place that we would be taken care of. So they went to see an attorney. They had a will put together. They named a caretaker, a guardian. They got a life insurance policy, a term policy. So if something happened to mom and dad, a couple had been named to take care of my sister and I, and a funding instrument put into place to make sure that we were going to be taken care of. A little bit later, they added a trust component to that. And at that point, they had put their plan together. And in the minds of mom and dad, they were done. Now, fast forward about 40 years, and I've had the opportunity as a best-selling author that's written books on financial planning and has spoken on the topic of estate planning in churches, colleges, universities, where I've done adult education events like I'm doing in this on-demand setting. I've spoken at civic and community settings. I've been at forums with attorney friends that I've had the privilege to come in and speak and to share my insights as a non-attorney professional speaking on these topics. And I was in town and had just done an event and stopped in to see mom and dad and have some dinner and was sharing with them the event we had done and the people we met and some of the things that I uncovered in conversations with the people that attended before and after the event that really validated some of the things I'm going to be sharing today. And I looked across the table and asked mom and dad, I said, now you guys have a plan in place. And dad smiled and said, yes, we did that when you're young, and shared the story that I shared with you. And I said, well, dad, when's the last time you updated your plan? And he looked at me kind of funny across the table. And I knew at that moment we had a little work to do. And I said, Dad, go get your plan. So he goes to the file cabinet where he keeps his important papers, and he comes in. And as we're going through his plan, sure enough, the plan they had created about 40 years ago had not been updated since that time. The couple that was going to be the guardians for my sister and I've been dead for years. The term life insurance policy that dad had purchased to provide the funding in the event they died early had long since gone. Assets that they had listed in the will and in the trust to be able to leave, those were gone because they had changed houses and over the years, different stuff, different bank accounts, things happened, but the plan hadn't been updated. So in the event if mom and dad had passed away without updating their plan, it would have really left my sister and I a mess to have to clean up. And by the same token, I think through my dad's brother, who was a CPA, that his idea of an estate plan was every time he would get a new girlfriend, he would handwrite a will, leaving everything he owned to his girlfriend. He never dated a single one of those documents. And when he died and we began to go through his files to try to see if there was a will in place, we found not one, but seven, leaving all of his stuff to a different girl that he had dated at one point in time in his life. That made for a very interesting probate scenario as we tried to figure all that out. He didn't have much left over, but it was an interesting time. And again, it leads to the conversation we're going to have today. Now, this is an important topic to me too, because I and my wife Yuri, that you see me featured with here, we're married. We have a blended family, and I have 6 wonderful children, 3 grandchildren. And as my kids have grown, and many of them are out of the house now, they have married, and They've started families of their own. And as a result of that, as our family grows, the importance of making sure that our estate plan is updated to address leaving the things that we want to leave to the kids and the grandkids that we love is current and up to date. That's one of the reasons I want to have this conversation with you, but also to share from my experience of what I've learned and to share some of the common mistakes I've seen in working in this market over many, many years as an educator. So, what are we going to learn today? We're going to talk about the wealth transfer, or the third phase of estate planning. Phase one of estate planning is when you started your working career and you began to accumulate assets, because you've got to have assets to have an estate. So as you opened your first checking account, you bought your first car, you bought your first home, you started building an estate. Now you may be in the retirement phase of life, which is phase two of estate planning, where you are taking the assets you've accumulated over your working careers and utilizing some of those assets to create income for you to live on. Well, you're retired. But the third phase of estate planning takes place when you die. And that's when the assets that remain are transferred to a surviving spouse, kids, grandkids, or a charity that you may want to leave some resources to when you're no longer gone. So these are the things that we're going to talk about. I hope you got a pen and a paper, because I want to share some things with you I think will be valuable information. Let's start with the need for estate planning. There's three important reasons you need to think about putting together an estate plan. The first of those is you've got to pay for dying. There is a cost to dying. There's a funeral that has to be paid for. And unless you do some unique types of planning we're going to talk about, your heirs are going to end up going through probate. And if you've got a fairly large estate, you may end up having to pay estate taxes as a result of that. The second, and what I think is the most important reason that you need to think about an estate plan, is as you pass away, don't you want to have the most efficient and effective way to transfer your assets as expeditiously as possible to your kids, your grandkids, surviving spouse, and not leave them in limbo or leave assets tied up in a probate scenario that don't have to be, and making sure that the things that you've accumulated you want to leave to the ones you love get there as quickly as possible. And another important reason is making sure that you've addressed the needs of a surviving spouse, as well as any minor children that may remain in the home, or special needs children that may need care for the rest of their lives. Making sure that there's a proper income plan in place to address those needs, and the appropriate guardians and caregivers have been appointed that can take care of those individuals that may need assistance if you're no longer there. Now, we talked about the cost of dying, and when we think about a funeral today, we're talking $7,000 to $12,000 on average here in the United States or Canada, which covers your funeral home, your burial in the cemetery, and your headstone. And while that's not a significant amount of money, there's not a lot of folks that can immediately go write a $7,000 to $12,000 check to pay for that when you pass away. So how do we pay those funeral costs? Well, we've already said you can pay cash to write a check out of the estate and pay for those out-of-pocket expenses with out-of-pocket money. The second way you could do that is to go visit the funeral home of your choice and purchase a prepaid plan. Now, what is a prepaid plan? It is an opportunity to purchase your funeral today and lock in today's pricing for a funeral that may not take place for months, years, or decades into the future. Or you can always go the life insurance route, where you purchase a life insurance policy and a portion of the proceeds from that life insurance policy can be used to create the cash to pay for the funeral. Or you can do an assignment of a portion of the death benefits to pay for the funeral. That's a conversation for you and your life insurance agent. But the failure to plan, to put an estate plan together, can be very expensive, because when you die, there are a lot of expenses that are likely going to be incurred by your estate. The medical expenses that led up to your death, whether illness or injury. We've already talked about the cost of a funeral. There are probate and estate administration expenses that your family may experience, as well as income taxes that are going to be due, and potentially death taxes if you have a large estate as well. So it's very important that you plan for these, because there are things you can do to mitigate these costs. But if you fail to plan, guess what? You've planned to fail. Now, another reason I believe estate planning is important, and it's often overlooked, is in the area of medical preparedness. We'll touch on this more a little further on in today's broadcast, but I do want to touch on it now. In the event you pass away, it's often as a result of an illness or an injury. So the big question is, what happens if you can't voice your concerns and you can't give voice to the type of care that you want to receive in the event that you are injured or you're sick and you can't speak for yourself? A living will is a document that allows you to provide guidance to your doctors that tell them the type of care that you want to receive, whether or not you want to receive pain relieving medications, you want food or water withheld, or you want surgeries performed in the event you've got a terminal illness or an injury is likely to result in your death. You can speak to what type of care that you want done, taking that burden off the family. Another important reason for estate planning is putting together a durable power of attorney. This allows you to appoint someone in advance to make healthcare decisions on your behalf and sign those healthcare documents. It allows you to appoint someone to take care of you personally, as well as someone who can write checks and manage your financial affairs in the event you can't. This is a significant issue in estate planning that is often overlooked. But as I've done events over the years teaching estate planning and medical preparedness, it's an area that I've heard horror stories again and again where these documents were not in place and it created a significant hardship on the family. Now, one of the main reasons that we do an estate plan is to make sure that we're caring for heirs, because estate planning isn't just about transferring the assets that remain when you die. It's about how these assets are going to be used by the people that you leave behind. Income planning is going to be an essential part of estate planning, making sure that money is going to be there for a surviving spouse, for minor children or special needs children. This is often overlooked. Did you know when you die, if you are receiving Social Security, as is your spouse, that when you die, one of those checks disappears? And if you're receiving a pension from a workplace that doesn't have a survivor benefit, that money disappears too. Oftentimes, we see surviving spouses, and women tend to outlive men by an average of 5 to 7 years. We oftentimes see women having their sole source of income after the death of their husband being their Social Security check. That is really a financial crime, and it's a failure to do proper planning. And I want to bring that to your perspective now, because you need to understand that life goes on for the people that you leave behind. Now, this is where life insurance can come in, because life insurance can provide the liquidity, as we've already talked about, to pay your final expenses, but it can also create an estate for your loved ones. It can provide an asset that can create ongoing income to provide for a surviving spouse, for minors, or for special needs children. That's very important. The other thing that's important is to make sure that whatever assets remain are going to be properly managed. And if you're going to be dealing with minor children or you're going to be dealing with special needs children, having someone that is financially savvy that can manage those assets for their benefit is going to be critical as a part of your plan. Now, I've brought up a couple of times, and I want to mention it again, special needs children, because we oftentimes see estate planning postponed for younger families just getting started. But death is no respecter of age, and young people die every year just as old people die every year. And making sure that there's a plan in place to provide for minor children or special needs children is extremely important. And as I've already stressed, making sure that there's a proper funding mechanism there so that the dollars are going to be there when they're needed, and the caretakers that you've asked to care for your kids if you're not there aren't going to be suffering financial duress by taking on the task of bringing your children into their family. Now, again, life happens, and it's important to remember, because it happened to my mom and dad. It happened to my uncle, although his was a little different. Estate planning is not a one-time event. And I can't tell you how many estate planning events I've done over the years where I've talked about estate planning, and I've been at forums with attorneys, and we've talked and we've done Q&A with couples, and we learned that they put a plan together but have never updated it. Or I've had an opportunity to meet with individuals that are serving as executors or serving as successor trustees, finding out that the plan that was put in place is either incorrect, incomplete, or just plain bad at that point because the information doesn't match the assets that exist today. Estate planning has to be updated as your situation changes. Why? Because, as I said, life goes on. Marriage, divorce, children, grandchildren, life happens. And when it does, the need to update your plan happens as well. Now let's take a minute to talk about probate. One of the most common mechanisms that we see used in estate planning is a will. It's probably the least expensive mechanism to put into place for estate planning, but it could be the most costly to have administered once you're gone. So, what is a will? It's a legal document prepared under state law that allows you to name the individuals who are going to receive your property when you go. Now, a will must be probated, and we'll talk about that process in a minute, and a will becomes part of the public record. That means anybody that you have listed in your will and the assets that they're going to be receiving, anyone can go to the courthouse and read that information and know what your heirs are going to be receiving. Now, why does probate come into play in all of this? Now, the word probate comes from the Latin, which means to prove or to validate. So, what is probate and why does a will have to be probated? Probate is the legal process following your death by which your will is validated as authentic, as in the case of my uncle, 7 signed wills, none dated, trying to figure out and put together a timeline of which woman he dated at what particular time in his life to try to determine which will was the last one that he wrote. It's also the time that your assets are accounted for, your debts are paid, and whatever's left over is ultimately transferred to the designated heirs. Now, keep in mind that any titled assets that you have, a house, a car, anything that has a title or a deed that has your name on it, has to be signed to be transferred. If you're dead, you can't sign your name to the deed or the title. So probate is the process that assigns someone to attach your name to those documents so that those properly titled assets can be transferred to the individuals that have been named to receive those at your death. Now, again, as I said earlier, probate is a public process, and your records are going to be open for court inspection. It's also important to remember that probate is court administered, and it's typically going to require that you hire an attorney to represent you and to pay those fees either yourself or out of the estate assets, one of the two. Now, some states may have a simplified probate process for very small estates, and that's going to vary state by state. It's important that you find those rules out and know what they are as they apply to your state. But one of the things we do know about probate is it can be a very cumbersome process at times. You know, on average, we see probate taking 6 to 9 months from start to finish. And if it's contested, where someone wants to come in and challenge what the will says and says, that is not right. You know, think of Howard Hughes and how many people rose up to say, hey, I'm Howard Hughes' child, or Howard Hughes promised to leave me something in his will, or other famous people that their wills have been challenged. Now you can see an estate plan tied up in probate for years and years. And the longer it's tied up, the more it costs. Now, the average cost for probate is typically around 3 to 7% of the gross value of your estate for the legal fees and the associated costs that are involved. But it's also important to remember that during probate, the assets of the deceased are typically frozen. And without court intervention and court permission, those assets can't be distributed, they can't be shared. You can't even write checks out of a bank account if that account has been frozen without the court's permission. Now, why do people do a will? They do it for peace of mind. They do it to avoid intestacy. What is intestacy? That is dying without a will. State has a plan for you. I'll touch on that in just a minute. Another reason that people use a will is have the ability to appoint a guardian for minor children, to choose the person that's going to help distribute their assets when they're gone. A will is used to make specific bequests, to leave unique things to individuals as they pass on, to be able to manage assets during probate, to be able to continue a business during probate, to be able to defer distributions to a minor until the appropriate time. These are some of the reasons a will is put in place. But if you don't have a will, again, no problem, because the state's written one for you if you haven't written one of your own. As I mentioned in the previous slide, it's called intestate, and that means dying without a will. For those who die without a will, the state has a standardized wealth transfer plan that they've put together to distribute assets based upon a formula that they've put together, and that's going to vary by state. But you may not agree with how they're going to distribute those assets. So people who don't know you or your family are going to be making those decisions for you if you haven't at least done the basics of putting a will in place. Now, if you don't like the idea of probate and you'd like to come up with ways to avoid it, there are ways to do that. And I want to take a minute to talk about those now. Now, again, it's important to remember that the goal of efficient wealth transfer is to make sure that the people you want to receive your stuff when you're gone get it as effectively and efficiently and as expeditiously as possible. And you want to make sure that the people you name to get your stuff are going to be the people that actually get it. So, what are some of the ways that we can avoid probate? Well, we can use joint tenancy, where we have two individuals owning the same piece of property. And at death, the surviving individual takes full ownership of that asset. Now, it doesn't avoid it, it only delays it, but it is a means to be able for husband and wife to own property together. And when the husband dies, if he dies first, the spouse can continue to own the property, but now we've simply delayed the inevitable. Now, in a community property state with rights of survivorship, if the property is titled that way, then the survivor is going to receive title at death. Again, if you haven't gone through the process of continually updating titles, we may defer but not completely avoid probate. There's what's called a Totten trust, which is used in the savings and loan institution to be able to pass a savings account on to heirs. We often see now with most of the banking institutions what are called transfer on death or pay on death designations that you can do to those type of accounts as well. Life insurance avoids probate because the proceeds are going to be paid directly to the named beneficiary at the death of the insured. Now, if you make gifts during your lifetime to kids, grandkids, or other individuals or charities, those gifts given before you die are given while you're alive. They don't have to be probated. You can also use a living trust, and we'll spend a little bit of time talking about that. And I already mentioned transfer on death or pay on death options that are available with banks and a lot of securities accounts today. But I mentioned a living trust, so let's take a minute to talk about a living trust and really kind of define what is a trust. A trust, by definition, is a fiduciary relationship in which one party, you, can give another party, the trustee, who can also be you, the right to hold title to property that you currently own or assets that you currently own, and transfer the ownership into a trust for the benefit of another person, you while you're alive, and your named beneficiaries at death. A revocable living trust doesn't die when you do. It is an artificial person, and as such, it allows you to avoid probate. There are strategies using a living trust where you can actually engage in estate tax mitigation strategies if you have a large estate. And it's a good thing to point out that if you do have a large estate, important to have a qualified CPA on your estate planning team to address those issues. The other thing that you can use with a trust is you can create provisions in the trust so that if you have someone that's not good with money, a minor child, special needs child, there can be professional management of assets, if required, built into that document. So let me give you an example of a trust. Let's look at John and Betty Smith. Now, John and Betty Smith on the far left side there in the kind of the bluish gray box, they have stuff. They want to create a trust for the benefit of themselves, but ultimately for their 4 children. So John and Betty Smith see an attorney, and they put together the John and Betty Smith Revocable Living Trust. They then transfer the ownership of their assets, their stuff, into the name of the trust. So now John and Betty don't own anything. It's owned by the trust. John and Betty Smith designate themselves as trustees. So as long as they are alive, they have the ability to manage those assets just as they did when they were individually owned. And then at the death of John and Betty Smith, they're going to name a successor trustee, one of the children, which in this scenario happened to be James, with Tim as a backup in the event James was unwilling or unable to make sure that the document called the trust that explains how all of the assets were going to be divided up among the 4 children would be divided. And outside of court intervention, outside of probate, James or Tim can come in and distribute the assets to themselves and their sisters, and life goes on. The idea really behind a revocable living trust is kind of like a treasure box. And oftentimes when I'm doing an estate planning event live, I'll have a small wooden box like this in front of me, and I'll have pieces of a Monopoly game that are there. I'll have a car, I'll have a house, I'll have a hotel, I'll have some money, I'll have some stocks, I'll have some mortgage deeds, and I'll put those in the box to represent the fact that I no longer own those. I've now put those into the trust, and the trust owns those assets on my behalf. Now, I in turn get a key, and I can lock the box so nobody can get into the box but me, but I leave a key or the ability to receive the key at my death to someone else. So they can ultimately, at my death, unlock the box, take out the car, the mortgaged house, or maybe it's paid off at this point. They can take out the stocks, the bonds, everything that's in there, and they can hand that out to the people I've named to receive my stuff. So if we think of a revocable living trust much like a treasure box, it's the ability to hold your treasures in trust. Now, why would we use a living trust? When we think about a revocable living trust, it's important to understand this, that a revocable living trust allows you to be able to transfer your titled property into a trust arrangement and to appoint a trustee to manage those assets on your behalf for as long as you're alive, and then ultimately be able to pass those on. Now, it's called revocable because during your lifetime, you can amend the trust, you can dissolve the trust, you can put assets into the trust, you can take assets out of the trust. You, as the trustee, continue to control what's in the trust. And it's called a living trust because it is established while you're alive. There are certain trusts called testamentary trusts that are created at your death as part of the probate process if specified in your will or designated by the court to take care of a minor child or a special needs child. But a revocable living trust is created while you're alive, and it gives you the ability to have a lot of flexibility in how that trust is operated. Now, there's some pros and cons to trust. Some of the advantages, and we've already talked about those, is the ability to avoid probate, if needed, professional management. You can name someone to be a trustee when you are no longer able because of incapacity or death to do so yourself. There's no court intervention, so everything is private. The successor trustee comes in at your death, reads the document, follows the instructions, and distributes the assets accordingly. Now, what are the disadvantages? The creditors may have additional time to file claims against the estate. So again, the bills have to be paid just like you go through the probate process. Still have to pay the bills. Creditors have a little more time when a trust is involved to file claims. The asset transfer process can be a little bit more time consuming because you've got to take a copy of the trust document down to the bank where the title is held, or to the dealership to get the title transferred, or to the revenue office, wherever you have to go to take care of that. And it's a little more expensive on the front end to do a trust than a will. But the privacy issues and the ability to avoid probate can really cause you to pay a little more now, but to pay a whole lot less down the road. Now, one other thing I want to mention, and I see this quite often, is people will create a trust, and that's the first step. And I've seen over the years a number of what I would call unscrupulous attorneys that have helped individuals put together a trust, but they never fund it. They never transfer the assets or in some way move the ownership of the assets into the trust. So those assets end up having to be probated at death, and it avoids the whole process of having the trust to avoid the probate scenario. So titled assets, deeded assets have to be transferred into the name of the trust prior to death to make sure that the probate process is mitigated. Now, let's take a minute and talk about beneficiary designations and how we're going to designate who is going to receive our stuff when we're gone. You know, most commonly when we think of designations of beneficiaries, we think of our spouse, our children, our grandchildren, other family members. We could name the estate itself. as a beneficiary. We could name the trust. If we create a living trust, it could be the beneficiary. We can leave money to a charity, to a corporation, or to a partnership. But again, it's important to keep those designations current. Remember what I talked about with my parents' planning, where they missed it in that area. Now, in your planning when it comes to beneficiaries, and especially your children, an important conversation you need to have with the team members who are going to be helping you with your plan is whether or not you're going to name your children to receive money per capita or per stirpes. Now, per capita literally means per head. That means if you have 4 children, like we saw with the Smith family, and one of those children predeceases the parents, then only the 3 remaining children would share in the assets. If you list a per stirpes designation, then that would allow the spouse or children, or a combination of those two, to receive the assets of a child that may have predeceased the parents. So as an example, I have a son that is married, and in the event something were to happen to him, if I selected per capita, then I would exclude my daughter-in-law from receiving any of the assets that would have gone to him. If I have named my son as a per stirpes beneficiary, then he would receive, or she would receive, the assets that would have gone to him as being a part of the family. Now, spouses do have rights, and in some states, there is specific rules and regulations regarding surviving spouses' assets or access to at least some of the estate assets. That is a conversation that, as you're visiting with your attorney and preparing your plan, you need to make sure that you've got properly addressed and put into place. Now, one area that is a concern that I want to mention is listing the estate as a beneficiary. I recently ran into a scenario like this where an asset had been left to the estate. And as a result of it being left to the estate, it had to be probated. And those assets became subject to the claims of the creditors. We've already talked about that process as being cumbersome and being very expensive. Now, another scenario is where the assets are left to the trust. And we recently saw a scenario with an individual that left some assets to the trust. And because the assets were left to the trust, the ability to take income over the lifetime of an individual had been negated. And because the trust became the recipient of that asset, the ability to provide that surviving family member with guaranteed lifetime income, which was the desire of the family member, was negated by poor planning on behalf of a team that put the plan together. And that money was only now going to be available for the next 10 years. And if that individual lives longer for 10 years, and it's very likely that they will because they were young, then those dollars are going to have to be paid out over a 10-year period and no longer. Again, beneficiary concerns are also important because if you name a minor as a beneficiary, in most states, a minor cannot inherit property or enter into contracts until their majority age. So if you name a minor as a beneficiary, the court has to appoint a guardian or an overseer, create what's called a conservatorship to oversee those assets until that child becomes majority age. That becomes a very restrictive, very cumbersome, and very expensive process that every time something needs to be done, you've got to have an attorney on your behalf go to the court and petition the court for things to take place. Again, a slow and cumbersome process that can be avoided with proper planning. Now, let's take just a moment and talk about estate taxes and life insurance. In the event you die and you've got a healthy estate, those estate taxes are due and payable in death. Now, estate taxes are imposed upon the value of the gross assets of an individual's estate or a couple's estate if they die together. Those taxes are payable in cash, typically within 9 months of death. There's going to be some administrative costs that we've already talked about, and there may be taxes both at the federal and the state levels that may be imposed. And then whatever's left over is going to be passed on to the heirs. Now, one of the ways that you can solve that problem is rather than having to liquidate assets, this is another use for life insurance to be able to pay these expenses. And for roughly 1% of the cost of an estate each year, a life insurance policy can be purchased that can pay those estate taxes at death, leaving the other assets intact so that they can be passed on for future generations. Think about a family farm that the bulk of the assets are tied up in land. Who wants to have to go liquidate a section of land to pay estate taxes when life insurance could provide the cash to do so? Now, let's go back and visit medical preparedness planning for just a minute. We talked about a living will and why a living will is important. Now, let's revisit that for just a moment. A living will is a written statement, oftentimes referred to as an advance medical directive, which allows you as an individual to state your healthcare wishes in the event you become seriously ill and you're unable to give consent. It allows you to state whether or not pain relieving medications will be provided or not, whether or not you want to receive food or water. In the event that your heart stops or you quit breathing, do you want to be resuscitated? Yes or no? Whether or not you want to have last rites or you want to have certain religious activities a part of your death as you're going through that process in hospice or at home. And you can also designate funeral or burial services and whether or not you want to be a donor as part of that living will. Now, the durable power of attorney, on the other hand, that we spoke about, oftentimes in some states referred to as a healthcare proxy, lets you name another individual to act as your agent to make healthcare decisions or to sign healthcare documents authorizing care to be administered in the event you are incapable of doing so. This is typically done through what's called a springing durable power of attorney, which means that the powers given to your agent only spring to life when you as an individual become incapacitated. And a HIPAA authorization as part of that can allow that individual to have access to your medical files and to be able to share that information with other parties that may need to review that for appropriate care that may need to be administered. Now, I want to spend just a moment talking about special needs trust because this is an area of increasing concern where I'm seeing this not being properly addressed. Now, when we talk about special needs trust, it's important to remember that the intent of this can be to create a unique type of trust that can allow your children that have special needs to also be able to access the public benefits for which they are entitled to, and not to create a scenario that excludes them or disqualifies them from those assets. You can create a plan so that Medicaid qualifications to be able to take care of the care that they need would limit the amount of assets that they can own or use for their benefits. Now, this is a very complicated area of law and the rules vary from state to state. So it's important that if you do need a special needs trust, that you work with an experienced, knowledgeable attorney that understands the rules of your state and can draft a plan that will take into account the qualified aid that that child may be eligible for, and to make sure that a plan is put in place that your distributions don't disrupt that. Government benefits can provide basic food, shelter, clothing needs, and we can use a special needs trust to take care of and to provide dollars for supplemental needs, things that may not be provided under government benefits for care, such as utilities, health care, specialized treatments for their condition, ongoing education, job training, or entertainment that that child may enjoy. Now, this again is a complicated decision and it's a difficult one. And again, I would recommend that you meet with qualified counsel to do that. You've got to decide whether or not you're going to intentionally disinherit a child with a disability or use a special needs trust to make sure that their interests are going to be taken care of long term. Now, I want to spend just a moment talking about the Stretch IRA because over the years, this has been used as an income continuation vehicle, but many individuals are not aware of some unique changes in the tax law that recently took place that modified how Stretch IRAs work. But what is a Stretch IRA? Well, let me start here. One of the major benefits of a traditional IRA, a simple or a SEP, is that money grows tax deferred until those funds are distributed. And since money grows tax deferred, the money that would have been paid in would have been paid in taxes continues to earn interest. And as a result of that, when you get to a certain age, Uncle Sam says that money has been deferred long enough, you've got to start taking a required minimum distribution. and taking a minimum dollar distribution out of those qualified IRA accounts on an annual basis. Today, it's typically age 72. The idea behind a stretch IRA was that it was a unique wealth transfer strategy that allows an individual to extend the deferral period of a traditional IRA, a simple IRA, or a SEP IRA. Now, this strategy was best used when the extra income was not needed in retirement and when the importance of leaving a legacy to a surviving spouse, kids, or grandkids in an income tax manner was very important. So, what are the mechanics of a stretch IRA? Well, the owner of the IRA would name a spouse or a younger person like a child or a grandchild as the beneficiary of the IRA. And only taking out the required minimum distributions, the minimum amount required, rather than taking substantial distributions from that, the goal was to take as little as possible and to allow what was left in that account to continue to grow. And then under IRS regulations, the ability to be able to take money from that account and pass that on to the kids, and they could take money for the rest of their lives. So there were some advantages to a stretch IRA. You could provide income for life to a chosen beneficiary or multiple beneficiaries that were the recipient of that income. You could also minimize your tax liability because you were taking smaller distributions out of that IRA rather than taking money out in a lump sum or taking larger periodic distributions. So you were paying less in taxes and the money continued to grow on a tax deferred basis, leaving more for your spouse, your kids, and your grandkids. However, there are some disadvantages to a stretch IRA. If a beneficiary dies early or may not live to normal life expectancy, then the hopefully gained benefits of extended tax deferral may not significantly work to their advantage. Now, the tax laws may change, and in fact, they have, and I want to talk about that here in just a moment, that change the way the rules work with the stretch IRA. Or if you're using investment vehicles that are tied to the market and those investments underperform, there may be less money there than you planned. Inflation, the monster lurking under the bed that eats away the purchasing power of your money, may eliminate or limit the value of those future IRA distributions. And then, of course, if you didn't take your required minimum distribution on an annual basis, there was a significant tax penalty, which was 50% of the amount that you should have taken. But what's recently happened, I want to point out, because this is the important area of the stretch IRA you need to know. And that is the fact that the Secure Act, which was passed at the end of 2019, changed the allowable period of time over which distributions from an inherited IRA can be made. The stretch is no longer the stretch unless it goes to a spouse. Now, if the money is left to a surviving spouse, the surviving spouse can continue to stretch the distributions over his or her lifetime. However, if you're leaving money now to a child or a grandchild, a non-spouse beneficiary can only stretch that inherited IRA over a period of no longer than 10 years. Under the old rules, a child or a grandchild could take income over their lifetime. So think about a 30-year-old inheriting money from a parent or a grandparent in an IRA, and they only had to take distributions based upon their life expectancy. They could stretch that money out for 30 or 40 years. Under the new rules, a spouse again can continue to take money over their lifetime, but a non-spouse beneficiary only has a 10-year window to withdraw those funds. Now, there are a couple of exceptions to that. Minor children, until the age of majority, can continue to utilize the stretch function. Disabled or chronically ill children or non-spouse beneficiaries who are no more than 10 years younger than the individual that died can still continue to stretch the IRA just as before. So as you can see, the rules have gotten a little bit more complicated. So as part of your team, you want to make sure you've got a qualified financial professional working with you that can help guide you in making those appropriate decisions in beneficiary designations and in planning, and then also be there to be able to give guidance and advice to surviving spouse, kids, and grandkids. Now, when we talk about stretch IRAs, I want to just mention real quickly that an annuity still remains a very attractive instrument because of the contractual guarantees and the downside risk protection that annuities provide. The enhanced riders offered by a number of annuity carriers can also provide additional benefits to you during your lifetime that in the event you get sick and require care, many of the annuities available today will provide additional dollars that can help you pay for care if needed. But an IRA doesn't just have to be an annuity. You can use mutual funds, brokerage account, managed money platforms, or banking products like a CD or a money market account. But each of these plans has its own risk and its own potential rewards. So again, the guidance of a knowledgeable financial professional is going to be recommended. Now, as we wrap up, I want to give you some points to ponder and some questions that I want to challenge you to think into. And these are questions that you should be having with the estate planning team that you're going to be working with to put together your plan. So here's some things to consider. Question number one, and it's pretty obvious. Do you have a will? Well, that's pretty much a yes or no. You either do or you don't. The second question, is it current? When is the last time you went back and reviewed your will to make sure that it is updated and current? I recently did an event where I mentioned that to an individual, and he got this funny look on his face, and he leaned over to his now new wife, and he said, "We've got to fix that when I get home, because if something happens to me, my ex-wife is the named beneficiary on my will and my life insurance. So that's important." Do you have written advanced medical directives in place so that in the event you can't express your medical wishes, they're stated in writing and you've appointed an individual or individuals to help in that process? Do you have a living trust? If so, is it current? Has it been properly funded, or have you just put the documents together and that's as far as you've gone? Now, do you need or have need for a irrevocable life insurance trust or trust on life insurance? We didn't touch on that, but again, if you've got a large estate, this is a conversation that you, your financial planner, and your CPA can have. Some additional points to ponder. Have you considered how your surviving spouse, your children, or your grandchildren may be financially impacted when you die? Have you sat down and done an analysis of the dollars that you're receiving, especially if you're in retirement or you're getting ready to go into retirement, and to see how the way you take income and the choices that are available to you may have adverse consequences to those you leave behind? Have you even thought about or put together a survivorship income plan? Have you made specific bequests to your heirs as part of your legacy plan? I remember when my grandmother found out she had terminal cancer. She was an antique dealer, and I loved what she did in her will. She assigned each of the grandkids a color, and when we went to her office, her place of business, grandmother, Mamaw as we called her, had done something really unique. She had taken little colored stickers and had put those underneath the antiques she wanted to leave to each of us. So the grandkids, the nieces, the nephews, and all the family, we had a really fun time going to my grandma's place of business. And as the executor of the estate, my dad would pick up a document, he would turn it over, and he would say, red dot, green dot, blue dot. And whichever family member that tied to, they would raise their hand, and he would set that asset in front of them. And we knew that Grandma loved us because she wanted us to have that. But then after we got done, then my dad, the executor, stepped up and he said, "Now, Mama had another statement that she made." He said, "She's given you what she wanted you to have, and now it's yours. But if there's something that you wanted from another family member, and they're willing to change or exchange something with you, and you're willing to make that trade, have fun. And we, for the next hour and a half, talked about the things that we had and whether or not we wanted to trade an item out. It was a lot of fun, and it was a great thing to do. Now, here's something I want to really stress. Do your family members understand the significance of what you're leaving behind? You know, one of the biggest tragedies I've seen over 30 plus years of speaking in the estate planning arena is the fact that I've seen families leave assets to their kids and their grandkids, but they have not given them the lessons learned along the way. They have not told them of the sweat and the toil that it took for that asset to come into their possession, and how they cared for that asset and managed that asset during their lifetime, and the reason they wanted to leave that to that child, and the dream and the goal and the vision they had for how they used that asset in the future. One of the most important gifts you can give the ones you leave behind is the gift of your knowledge and your insight and your wisdom. Now, lastly, you mentioned this. Does it make sense to use a stretch IRA strategy to create a planned income stream for your surviving spouse or other family members at your death? And then here's the last one. Have you considered the financial statement that you're leaving to the next generation, and how you're preparing your heirs to continue the legacy for generations to follow? You know, in the Bible, it says a good man leaves an inheritance to his children's children. And if we go back and we look in ancient times, people passed their estate from generation to generation. And they gave with them not only the assets, but the knowledge and the history and the wisdom behind it, and instilled with them the passion and the purpose to manage that asset well, so that that asset could continue on to future generations. We see that still taking place here in the United States today in the family farm that passes on from generation to generation to generation. Businesses that are in their third and fourth generation, where the parents and the grandparents and the great grandparents have not only passed on the legacy they've built, but the wisdom to continue and to grow and to expand that legacy for future generations. That's my hope and wish for you at the end of this. So, what are your next steps as we wrap up? Well, let me encourage you to do this. You were invited to this event today by a professional that wanted you to hear this information. And what I would like to encourage you to do is to schedule a complimentary appointment with them to talk about what I shared in this adult educational event. I'd like to encourage you to get the answers to the questions that we talked about, and questions that you may have arisen and written down as we spent this time together. And with them, let me encourage you to review your planning options, if you haven't already done so, to get the process started. Now, you need to put together a team, and this is where the individual that invited you can help. You need an attorney who's familiar with the estate planning laws of your state that can help put the documents together that you need based upon your wants and needs and unique situation. If you've got a larger estate, then you need to include an accountant that can help with the estate taxation issues, and that can help filing with end-of-life tax returns that may be involved. You need an insurance agent that is familiar with the use of life insurance products and other insurance products like annuities that may be part of the planning or transfer process. And you also need somebody that is knowledgeable in the investment arena, or you need to have someone on the team that can function as a professional manager of assets for minor or special needs children. Now, one of the unique things that the professional that invited you to this event has done is they've been able to help put all of these members of the team together in a very unique setting. They have assembled an experienced estate planning team that you can simply plug and play with. And they've given you the ability in this COVID-19 pandemic time in which we still find ourselves to engage with you in a highly secure portal. So you don't have to go to the attorney's office. They're going to come to you either by phone or video conference, as would the CPA if needed, as would the financial planner and the professional money manager or the professional asset manager if needed. And the nice thing about this highly secure online portal process is you've got 24/7 access, 365 days a year to your planning documents. And anytime you need to make revisions, it's a simple task to simply log in, make the changes to your plan, and your plan is automatically updated. You don't have to keep going back to the attorney and paying outrageous fees to update your plan as life changes. And best of all, the program they put together is affordable. They're going to bring it all together for you. They have an opportunity to introduce you to a national network of estate planning attorneys that work inside of this secure online portal. Now, they can work with your tax professional or you can work with one of theirs. They are a knowledgeable financial professional or a knowledgeable tax professional or a knowledgeable attorney that invited you in the first place, but they have the other team members available to work with them. But here's the most important thing. Everyone on the team is working for you. You have the right to hire, you have the right to fire, and they are going to do what you ask them to do because they're working for you. And together, they're going to help you put together a customized plan that is going to help you make sure that your wants, your wishes, and your legacy are properly documented, and the plans that you have for your assets and for the gifts that you want to leave to the people you love are documented and prepared so when you're no longer here, those who are left behind will get the best I love you gift of all, and that is a plan. If you prepare today, you're prepared for tomorrow. So I want to thank you for attending. And I want to let you know that the financial professional, legal professional, or tax professional who invited you here is going to be in touch with you soon to talk about next steps. I want to thank you for taking time to spend this hour with me. I hope you found it as beneficial as others that have heard this message over the years. And I want to personally thank you for attending. Have a great day.